This is a really big case. For those of you who didn't read anybody read about this in my NMAR Voice article? Kathy read my NMAR, one person. Oh no, Tina and Lois and Bev, of course, and Kim, yes. Thank you so much for reading my NMAR Voice article. Does anybody know I have? Right, the NMAR Voice article. Every quarter, guys, like the first week after the end of the quarter, the NMAR Voice comes out. Are we still calling it the NMAR Voice, Barbara? It's called the Voice? Okay. So in the Voice, there is a section that I write for your benefit. That is some big issue that's happening here in New Mexico, something relevant to what and I know it's relevant because you call me on the hotline and tell me this is relevant. So I'm writing something that's not, something that's really impacting you. The whole thing's great. The Voice is great, right? Pictures of the conference, you see your friends, you hear about RPAC stuff, and all the great things the association's doing for you. But I encourage you, if you don't have time to look at all that, just get to my section and read the articles, guys, because this is important stuff. It really is. And if you're not if you're not getting those emails, make sure that you get in touch with NMAR and find out why. A lot of you, unknowingly or maybe knowingly, opted out of receiving anything from NMAR. So when you call and find out why I'm not getting this, oh yeah, you opted out 3 years ago. We haven't sent you anything in that time frame. But this is a really great resource for you guys. So please take advantage of it. But this particular case, so buyer and seller go under contract. That's how every story starts out, right? Everybody calls me on the hotline. Buyer and seller go under contract, and then we just walk through the process. So buyer makes some objections to things that were wrong with the property, including when it went to the roof. And so the seller says, I'll fix the roof. And so the seller turns to his listing broker and he says, will you give me some names of roofers? And the listing broker gives him a few names of roofers. And the seller, my husband says I'm terrible with programs. Who's the he, actually? Who's the he? He, the seller, he interviews them. He gets bids from the roofers, and he accepts, I know this is going to come as a great surprise, the cheapest bid, right? That never happens. And that roofer gets up on the roof and thinks it'd be a good idea to use a blowtorch on the roof, and he burns the house to the ground. To the ground. This is now a piece of vacant land. I think it was at $280,000 for the improvements. I think the land sold for $100,000 or something like that, right? So, dun dun dun. So, of course, there is insurance, so that's great news. There's property insurance, and so as you guys know, in our listing agreement, we require that the owners maintain property insurance. So the insurance kicks in. That's the good news. But insurance companies have this thing called subrogation rights, and so they have a right to go after the party who's actually at fault. So, for example, if you get into a car accident, if your insurance company has to pay out on your behalf because of the car accident, but if the car accident was somebody else's fault, they're going after that other person. If they have insurance, then the insurance will pay it. And if they don't have insurance, they can go after that person individually, personally, to collect that money. Those are subrogation rights, guys. And so they had subrogation rights. So they were going to go after the roofer, right? Because he's the one who burned the house to the ground. Thought the torch was a good idea. But in this case, the roofer was not licensed. And the roofer had no insurance. And the roofer was gone. So guess who they went after? The realtors. Under the theory of negligent referral. They actually called it negligent hiring, negligent selection. That was actually what they put in the complaint. But it's basically negligent referral. And they said that the broker had an obligation to make sure that all the names that he gave to the seller for roofers were actually roofers. Licensed contractors who had appropriate insurance due to the job that they were being referred to do. Okay, so that's the allegation. And then they named the qualifying broker in that lawsuit too, because they said that the qualifying broker failed to supervise and train the associate broker and tell them the importance. Yes, I'm talking to you, Gene.
This is on the buyer side. The buyer.
Yeah, the buyer. Yeah. No, this is the insurance company.
And they're going after the buyer.
No, they're going after the listing broker who gave the names. Yeah, the listing broker gave the names to their client, the seller, right? And they said that he was wrong because he didn't check them out first. Then they said that the QB was wrong because they didn't tell the associate broker the importance of checking out their referrals first.
Actually, I'm texting my client.
But you see, even when you have insurance, you're not off the hook, right? Even when there's insurance, but you have to make sure there's insurance. Always, you guys. And I know you guys don't, ask for copies of insurance, but I do every once in a while. I get a call saying my client has been honest and forthright and told me they don't have insurance. Should I take this listing? And I don't say yes or no, but I go through the entire analysis. Just yes or no. Everybody wonders why I'm on the phone for like 25 hours a day. And it's because I don't just say yes or no. So they call their, and they say, we've just gotten sued, right, for this negligent referral action. And, says, oh, that's property damage. You don't have any coverage for that. How many of you guys have Rice insurance in here? You have no coverage for property damage. You have no coverage for personal injury. I talked to you about that a few years ago. People were getting hurt on properties with no homeowners insurance. And they were going after the seller who had no homeowners insurance. And so when they found out there's no insurance, they'd go after the brokers and everybody. And you have no coverage in your policy with Rice. Now, with that said, I've gone to Rice and I have tried to get this gap closed. I've had conversations with them about it. The other issue that I've gone to them about is upping the policy amounts mainly for commercial folks, but also for some of you high-end residential brokers. Maybe you don't have enough coverage. I got 50% of it done. I got higher limits, and we are working on those numbers right now, and we should have those out probably by mid-year, where you can purchase additional coverage under Rice. So you can, in the event that you want to do that. But right now, they're still telling me no coverage for personal injury and property damage. And that's a huge, you could drive a truck through that gap in your coverage, guys. Crest Insurance does have some coverage for that. Anybody have Crest in here? Yeah, some does. So, it's very important, you guys, because Rice covers some things that Crest doesn't, and Crest covers some things that Rice doesn't, right? So I'm not telling you that the perfect solution is to buy insurance for both, but maybe the perfect solution is to buy insurance for both. But really look at the two policies, right, and figure out what is covered under each. Because I know that Crest does have some coverage for this, and Rice has no coverage, and I'm not giving up, I'm not done with the fight, but so far I haven't been able to get them to do anything about that, all right? So that, thankfully, I'll come back to one other thing in a minute. Initially the QB's business insurance kicked in to defend the QB. And initially they left the AB out high and dry. Now how does that work, right? This is an agent of the QB. So how can you cover the QB and not cover the AB? And so the private attorney that the AB had to hire and pay out of pocket to defend him for quite a long time, I don't know, it was like a year and a half into this lawsuit, finally got the business insurance that the company had to step in and defend the associate broker as well. Yeah, and to pay the back attorney fees. So you might have some insurance coverage through your general liability program. So look into that as well, you guys, okay? Because that's what's happening now. Now, I don't know, I talked to the attorney who was representing that associate broker the other day, and he said that his understanding that they are going to pay damages, not just defense costs. Because like I said, some insurance policies will defend you and help you win. Because if you lose, they don't pay for the damages as a result. Initially, it looked like that's what was going to happen, but when talking with this attorney the other day that was representing the associate broker initially, I think that the insurance company may pay damages. So this NAR testimony, I know this sounds like a great idea in theory. So years ago, NAR was testifying because it was a challenge to one of the MLS rules regarding, it had to do with limited service brokerage, guys. And NAR was talking about, up in Washington, on the Hill, during congressional testimony, there was the president, past president of NAR, was talking about all the benefits of hiring a realtor, right? I mean, a full-blown, full-service realtor. And I agree with all of the things she said. She came up with 183 things that your listing broker will do for you, and she read those into the record, the congressional record, right, where she submitted those as part of the congressional record. That is being used against this broker in this case. Because they have taken, one of those things is they will vet, that's one of the things that they will vet all of the vendors that they recommend and make sure that they are referring vendors who are appropriate for the job and licensed for the job and these kind of things. So their expert witnesses use this to say this is the standard of care set by the National Association of Realtors, because this was National Association of Realtor representative, past president, testifying before Congress that this was part of what they'll do for you. So it's a double-edged sword, isn't it, guys? So you want to talk about all the great things you can do for your client and kind of justify, why you're there and what you'll be doing and make them understand how it works, but be careful, right? Because that's how this is being used. So I had to reach out to the National Association of Realtors, and I had to ask them to please provide us with something for this broker's defense that says this is not the standard of care, that we do have that. What is that called? That's called the Code of Ethics, right? That is NAR's adopted kind of standard of care. It is not some testimony that was created. So they did actually put a letter together, NAR did, another pronoun they. NAR put a letter together and sent it that we sent off to the defense attorney for this associate broker and the qualifying broker to say that this is not the standard of care, and they did not, NAR as an association has not adopted this 183 things. Because if I have sent this to a couple of people in this room who I think are awesome brokers, I mean, all of them are awesome brokers, but I asked them to go through that, and I don't know, they found like, 25, 30 things or 50 things that are actually done by even the best of brokers. And the other stuff is not happening, guys. If you look at this list, you will just be like, oh my gosh, no, I don't do that. No, not that either. And nor should you have to. I mean, it's crazy stuff, some crazy stuff, right? I mean, it's a whole bunch of stuff. So just be careful. Some of the local associations and state associations have put this out on their websites. Brokerages have published this saying, look at all the great things that we'll do for you. This can be used against you, and it is being used against this broker in this scenario. So, and this is a national insurance company. So when I was talking about this issue at the National Association Legal Update, I said, this isn't like a, just New Mexico situation. This is a national insurance company going after this broker and using this. So it's not the first time we're going to see it. If this is the first time we're going to see it, it's not the last time we're going to see it. Okay. So anyway, that was interesting. Similar situation, not quite as crazy, but it was a situation where there was a referral to a home inspector who missed a whole bunch of stuff. And once the buyer got into the property, they found there's about, $30,000 worth of stuff that this inspector had missed, and went to talk to the inspector about it, and the inspector had no insurance and no resources to pay anything to this buyer. And so, as you know, what happens next? They go to the broker. And in this case, it was a small rural community in New Mexico, and they didn't have a whole bunch of home inspectors. You guys that are living in the bigger areas are very fortunate to have choices. There should never be a list with less than 3 names on it from you guys. These smaller areas, it's more challenging to do that. But this was the scenario. And so this broker had given this buyer one name.
The only one available.
The only one available, exactly. And he had no insurance, and there was no money available. So this is the realtor for Negligent Referral. So, we had, so this just goes on and on, guys. So, I have in my last one, I talked to you about the Negligent Referral one, also talks about this last one that I just published at the end of December. My NMAR voice is all about clear cooperation. So it talks about all the stuff we've talked about today about clear cooperation and some. But I say in the one that are before that on this case, if you're referring home inspectors and everybody, you're at risk of being sued for negligent referral. That's it. But the good news is that just the fact you referred them doesn't create liability. Okay, you have to prove that they have to prove that you were negligent in referring them, right? So how do they prove that they were negligent in referring them? We'll talk about that in a minute. But what are some of the things that I can talk about now. Some of the things that may include, for example, if you are referring a contractor to do a contractor's job, or trying to refer a contractor, and they actually aren't a contractor, right? They don't have the proper licensure, they don't have the proper insurance, they aren't licensed by the state, and yet you're referring them to do a job that requires them to be licensed. That's an example of how you could get to negligence under negligent referral. The fact that a vendor has multiple lawsuits against them. If you go to nmports.gov or nmports.com, either one will get you there, and you pull up the name of the vendor, and you see they've been sued 10 times. It's a public-facing website; anybody can look at it. And you refer you're referring that person on a regular basis. That could create problems for you. right? Or if you're, you're aware of dissatisfied customers, you are referring somebody, you do a Google search and, it comes up with 1 star and 100 different reviews from people saying how horrible they were. So, I mean, I know it seems absolutely horrible that you guys have to, deal with this, but it's the reality of the situation. Now, as we know, in January of this year, the commission created a new rule, and the new rule required all property managers, well, it was intended to cover all property managers who were hiring people to work on their houses that they were managing, to make sure that those people had the proper licensures and insurance for the job that they were doing, right, in the property management context. Now, interestingly enough, it's in the property management section of the Real Estate Commission regulations, but it doesn't say property managers, it says brokers. And as a result, the commission, well, I shouldn't say the commission, because I always say that like Wayne's the commission, and Wayne's not the commission. He's the head of the commission, works for the commission, he's the secretary over there, which is, it's kind of a funny word, isn't it? He's not the one answering the phones, he's the one in charge, but they call him the secretary. Anyway, he has taken a position that it very well could be interpreted to mean all brokers have to make sure. Now, the key, and I think the commission, as we get further along here, we'll talk about what they're looking at doing, the rules that they're proposing or discussing. They need to create a definition for hiring, but the rule does say if you're hiring the vendor, okay? And I know that sometimes when your folks are out of state, your buyers, your sellers are out of state, maybe you are hiring them, maybe you are choosing them, maybe you are paying them. But in most cases, you're not hiring them, I would say, right? You may be calling them up and making the appointment after you've given the 3 names, and your consumer has picked one of those 3 names, and your consumer is going to pay them, and they've asked you to pick up the phone and make the appointment. And I would not say that that is hiring. I mean, I couldn't say definitively because we have no definition of that in the regulations, but if you just look to the general definition of hiring, that's not hiring, just picking up the phone and making the appointment, right? So if that's all you're doing, then you're probably not hiring them enough to fall under that rule that the Real Estate Commission has promulgated. But with that said, there's nothing that prohibits you and should never prohibit you from making sure the people you're recommending, even though you're not hiring them, do have proper certifications. As I say here, most jurisdictions have only recognized claims for negligent referrals in the area of medical malpractice. However, the claim is being extended to attorneys and to real estate brokers. Which makes me really nervous when I send out a list of attorney names to everybody when they call me. Because I have to be concerned about that too. Whenever you're referring people, you have to look into their background, or you can create liability for yourself and for your qualifying broker. I will tell you, if this broker survives this, this is going to be their biggest, strongest argument right here. So all you people that tell me the forms are too long, too many, well, there's no such thing as too many. You don't have to use them. They're not, and they're not too many. I will not go with too many because they're in there for your benefit. They're not too many. You guys, I got a call from the disciplinary board of the state bar, the association, about 6 weeks ago. And we were having a discussion about something else. He called me about somebody practicing law who shouldn't be practicing law. And in that process, he knows who I am. And he said, I wanted to talk to you about brokers and, what they're doing, because I have seen some language brokers have written that have gone beyond the scope. And I'm not going to lecture you guys again today. I do that every single time I'm up here, and I know you don't want to hear it anymore. But we create the form so you don't have to create the language, because you're not allowed to create the language. I've said this 100 times. And we've been very fortunate that the state bar, the disciplinary board, the Supreme Court of New Mexico, all who enforce the unauthorized practice of law in New Mexico, have for the most part turned away and let you guys do your thing, right? We don't want them changing that. We don't want them to be in our business. But we have to be careful, and we create the forms so that you don't have to create the language, right? So not too many forms. I'm never going to buy into that. But even the length of the forms, that is what I get a lot of flack for, which, by the way, for those of you who are coming tomorrow, will learn that our residential purchase agreement has gone from 16 pages to 15 pages. And if I'm here for another 13 years, we'll get a page. It's not even smaller words. No, I actually didn't reduce font. I was more concise in the way I worded things. This paragraph, though, guys, that we put in the purchase agreement and the listing agreement a number of years ago is going to be huge in defending these brokers. It's the service provider recommendation paragraph, and it says that if a broker recommends a service provider to you buyer, to you seller, that you will independently investigate that provider. That is going to be these brokers' best defense. So yes, did it take up a little extra space in our forms to say that? Yes. But is it well worth it if it keeps these brokers from having to pay $280,000 out of pocket? Yes, it is. Yeah. We've also created a form, a vendor certification or vendor information sheet that allows you to solicit information from vendors. And it was targeted for property managers under the new rule, but you guys can use it too. So when you're referring somebody or you want to put them on your list of referrals, you can ask them with this form, do you have proper certifications? What is your license number? Let me get a copy of your insurance. You can use this form to create your list. Yes, because like I said, it's not just the fact that you referred them and they screwed up that creates liability for you. You have got to have been negligent in referring them, right? So if you've solicited all the right information, you're asking all the right questions to get the right information, that puts big holes in a negligent referral action, right? It shows you were being due diligent, that you were trying to get it right. And I understand that insurance can be canceled tomorrow and certifications can go away tomorrow, but the effort is being made, and that's how you avoid negligence, guys, right? Right. So you can utilize that form for that very purpose. If you guys have home inspectors on your list, I've talked to you about this before. We have home inspector licensing in our state now. Hallelujah, right? Yay. It took effect January 1st, but we do not have any regulations in place. I think we do have a board in place, maybe. But I know that, Wayne is out on admin leave right now, or taking the leave, and he was kind of handling that. So I was asking Steve the other day, what's happening with the board? And Steve wasn't sure what's going on with the board. Steve doesn't know what's happening with the board, then nobody knows what's happening with the board. So we are going to have home inspector licensing, guys, and when it actually happens, they have to create the regulations about what kind of testing is required and a lot of the requirements, the fees, everything. So until that gets done, we really don't have home inspector licensing in the state, and that could, as you guys know, the way government works, that could take a whole other year for us to get all that in place. When it does get in place, guys, you better be making sure your home inspectors are licensed in New Mexico before you put them on the list, right? They will have to have insurance. They will. A lot of your inspector contracts, you see language in there now limiting their liability to the cost of the inspection. I don't care if your house burned down. I'm going to pay you $250. That's what I charge you for that's all you're getting out of me. So when we were writing the bill, because I was involved in the drafting of that bill, I said, that's not going to happen. You're not going to have that in there. So we compromised, and we did say that they can limit their liability to the cost of, the per claim amount as dictated by the licensing board. So the licensing board is going to go in there and say exactly, how much insurance they have to have, per claim amounts and aggregate amounts. They can limit it to the per claim amount, but they can't limit it any less than that, okay? So it was a compromise. Like I said, they wanted to limit it to $250, and I didn't want any limits at all. So we kind of compromised. But right now, even without home inspector licensing in our state, there are trade associations like our Realtor Trade Association, ASHI, they're trade associations for the home inspectors. They don't require insurance, but they encourage it. They require national testing. They require continuing education. So you guys can still find out, make sure that you're hiring people that have, some insurance and some education, even though we don't have licensing in our state. Interestingly enough, according to the international website, they have a program which will indemnify any real estate license agent in the amount of $10,000 if a third party successfully sues the agent for negligent referral of an international inspector. I don't know if that's a RESPA issue or not, but we're not going to talk about that today. But they have this program set up now. So if you register through the program and you end up using an international inspector and you got hit with a negligent referral case, you have some indemnification, which means they step in and they pay some money, and it'll be up to $10,000. Okay. Additional thoughts. I talked about home inspector licensing, and the Act requires that they be licensed and insured. They pass a nationally recognized test. They take continuing education. One thing I'd like to say about radon, which you may or may not know about radon, is that radon mitigation companies must be licensed as general contractors if they are cutting, coring, boring, or drilling through concrete. Okay, and the high majority of the homes requiring radon mitigation require one of those things to be done. So they do have to have a contractor's license to do that. All right, and you can go there to find out some more information on radon. So what I said in my article and what I'll say today, which you guys will completely ignore me, I know that, which is why I don't stop right there, is don't make referrals. In my perfect world, you guys are telling them to go to this great big thing called the internet, where they can type in names and things pop up, and you're not making any referrals at all in my world, right? So, especially, when it comes to home inspections or repairs on property. But if you can't resist making a referral, always provide multiple names. I know you've heard this a bunch of times, and I know it's hard in small communities where you don't have a bunch of people that you can refer. But in that case, don't refer anybody. Really, if you only can put one name on your list, don't refer anybody. I'm not even kidding, guys, right? Check with the accrediting agency and for complaints filed against the vendor. These are things that you can do to mitigate the possibility. Check in imports.gov or .com. Like I said, either way, it'll pull it up and find out if the person you've been referring has been sued 100 times. Check with your insurance company to determine if you have any coverage for negligent referrals. And what they probably will say, well, it depends on what the damages are. Because again, if the damage involves personal injury or property damage, at least under Rice, you're not going to have coverage. So it probably depends on what the damage ends up being. But a lot of times it is property damage, right, or something to that effect for referral. Along the lines of negligent referrals, I want to point out that this doesn't just pertain to home inspectors, guys. This pertains to title companies and lenders and escrow companies and everything that you refer, okay? Absolutely everything. So escrow companies are governed by the New Mexico Escrow Act, and they are regulated by the Financial Institutions Division in the state here of New Mexico. And in the last 5 years, we've had Farmington has closed because there's been a bunch of money taken away from a escrow company embezzlement in Farmington. A Deming escrow company closed. Roswell is currently, the escrow company down there is currently under investigation. The only requirement under the act, which is pretty much a joke, I was going to put a laughing emoji up here because I thought it's $100,000 surety bond. That's all that's required for escrow companies in the state of New Mexico. Pretty scary. How much do you think? How much of what they're doing is covered by the surety bond? Not even 10%, guys. This information, I have my friend Rick Tom. He owns Security Escrow. It's the oldest escrow company in the state of New Mexico. He's here out of Albuquerque, but he services real estate contracts from around the state. I went to him to talk to him about this issue when this Roswell thing came up. I was being contacted by brokers down there about the concern. I said, I understand what's required under the act, but realistically, what are you carrying for insurance? I mean, and these are the numbers he gave me. So the general liability policy is $4 million. Professional liability, $1 million. Crime, $1 million. That includes employee theft, embezzlement. Employment practices for wrongful termination, sexual harassment. If you don't have insurance for that stuff, that's a lot of the reason, sometimes when things go wrong and money starts disappearing from accounts, and I'm not talking about any of these specifically, but it's because they've had to pay out on other claims, right? And they don't have the funds available, or they don't have the insurance in place to cover it, so they end up borrowing a little from the account, right? So even though that doesn't directly deal with money being taken from the account, if you know you have insurance for these things, it's less likely you're going to have to borrow from the coffers, right, to cover them. Cyber liability, if they get, they get hacked and money gets transferred $1 million. So these are just some of the numbers that Security Escrow is giving me about insurance. So you guys, I'm not referring them. This is just information. Though I do think they're fabulous. So, and Rick Tom is wonderful. He's a broker member, and he's been an RPAC contributor every year. He was on the RPAC trustees. He's one of your fellow brokers. Great guy. But my point being is that there are insurances that these escrow companies can get above and beyond the $100,000 surety bond that's required by law that can protect the consumers in these situations. And this negligent referral situation goes way beyond just home inspectors, guys, right? I had a broker call me when the escrow company down there folded and said, asked me, what does this mean for my brokers who refer people to that escrow company? and now their money is gone. And you know how they found out, how this whole thing came to light, is that it's a small town. We're in Roswell, it's not a big town, right? And the buyers and sellers run into each other at the hardware store somewhere. And they said, hey, so what'd you do with that big payment that I made, when I paid off that $250,000 real estate contract that we had? And the seller looked at him and said, what big payment? And then the ball started rolling down the hill. So, I warn you guys, in every aspect, there's potential, I see digital liability everywhere, it's my nature, but you do have to be careful when you're referring even escrow companies, lenders, title companies, all of these things.